Mr. Keefe, are we ready on Yeomans?
To the best of my knowledge, Your Honor.
Who's on the Samsung SMG99? Is that Mr. Latta?
Yes, Your Honor.
Okay, thank you. Is Chapman here?
I have not seen him. Victim's here.
Okay.
Your Honor, I spoke with Mr. Chapman yesterday. He was aware that he had an in-person hearing today. He indicated he believed he might be running a little behind because he was trying to arrange a ride to court from Flint. He did indicate he would be there, but I'd ask that the court give him a little extra time given the distance that he's traveling.
You will see it call in the hallway and ask if Deontay Chapman is here. Thank you. Sean ready? Sean. He's out there. Okay. All right, we're on the record in the matter of the people of the state of Michigan versus Paige Lynn Yeomans, file number 22-00469 SM. Council appearances, please.
Morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Paige Yeomans, who is present via Zoom.
Thank you. And today was the date that was set for final pretrial. Do we have victims here?
Your Honor, I did call the hallway once about 15 minutes ago, and she was not present. If I could just take a minute and go over it, check again.
Okay, thank you.
Your Honor, it does not appear that the victims have appeared this morning, so people will be unable to proceed at this point.
Okay, sounds good. Okay, Ms. Yeomans, are you there?
Yes, I am, Your Honor.
Okay, so today was this date that was set for your final pretrial. However, the necessary witnesses have not appeared, so the people are unable to proceed. So this matter will be dismissed without prejudice today, okay?
Okay,
Okay, so the without prejudice simply means that if they do later regain communication with the necessary witness and they're ready to proceed, they do have the right to reissue the charge against you, ma'am. You understand that?
yes, Your Honor.
Okay, you want to give us at least 72 hours to get anything in lien removed as it relates to a no contact order, so that you don't find yourself in violation of that while this matter is now dismissed. And we'll mail you a copy of the dismissal, okay, ma'am?
All right, thank you, Your Honor.
Do you have any questions?
No, ma'am.
Any
No,
additional matters for
you.
the record?
Nothing further from the people.
No, Your Honor. Thank you.
You're all set, ma'am.
Thank you, Your Honor.
You're welcome. Okay, Mr. Keithy, are you handling Walsh?
I am, Your Honor. If I could have a few minutes to meet with her in a breakout room.
Ms. Smith, APA Smith, which one are you here for?
For the Walsh sentencing, Your Honor. Good morning.
Good morning. Okay, Walsh. Let's see, Brian Bomar Griffin. Is that a victim?
No, he is the felony matter for failed to appear on Thursday.
Oh, okay.
And him and Mr. Nicolard are supposed to be appearing this morning to address the warrant.
Sounds good. I don't see Mr. Nichols at this time. Okay, good morning, Mr. Basiga.
Good morning, Your Honor.
Here from Mr. Latta, correct?
That's correct, Your Honor.
Okay, we're on the record in the matter, the people of the state of Michigan versus Garrett Latta, file number 20-03383 SM. Council appearance, please.
Morning, Your Honor, Andrew Lee, appearing on behalf of the people.
Morning, Your Honor. Brendan Basiga appearing on behalf of Mr. Garrett Latta.
Thank you. Today was the date that was set for sentencing. Mr. Latta pled guilty to a count 1 of misdemeanor domestic violence. I do have a pre-sentence report and recommendation prepared on May 3rd, 2022 with an updated report also with that same date on it, giving information about restitution. Did you get a copy of those reports, Mr. Basiga?
I did, and we had a chance to review those, and I have no additions, deletions, or corrections, Your Honor.
Okay, you can proceed with any allocation.
Thank you, Your Honor. At this time, I'd like to incorporate the arguments that I stated in my submitted sentencing memorandum on behalf of Mr. Garrett Latta. With that being said, Your Honor, I'll keep my comments rather succinct. Essentially, Your Honor, in a phrase, if ever there was a candidate for 7694A, Mr. Garrett Latta is it. He's accepted responsibility for what happened. He has the support of the community, as is demonstrated by Exhibit C. Your Honor, he is fully employed. These are exhibits, A through C that I submitted. Your Honor, Mr. Latta's situation, Mr. Latta himself, are essentially what 7694A was designed for. I'm happy to see that the recommendation from probation agrees. Well, I should say that more appropriately here. I agree with the recommendation of probation. I think Mr. Latta should be and ought to be given an opportunity to prove to this court that he is worthy of the privilege of 7694A. Certainly, addressing the sentencing principles, there will be restitution. There's going to be rehabilitative measures. There's going to be things that are put in place throughout the course of probation that will allow him to address and give him the tools needed to not just avoid, but deal with situations of this nature in a better fashion. So that being said, Your Honor, I am asking the court to grant him the 7694A status, to suspend any incarceration, and to sentence him to a term of probation. Thank you.
your client wish to make a statement at all?
Here, you go. Sorry.
It's up to you,
Mr.
Mr.
Latta,
Latta. You don't have to make a statement, but if you want to, I'll give you an opportunity now.
I don't really have anything else to say, Your Honor.
I would just note that I'm sorry, Your Honor. I would just note that he did make a statement he did write a letter to the court, Your Honor.
As part of his pre-sentence report?
No, Your Honor, that was submitted as part of the sentencing memorandum. I believe that's Exhibit B.
Okay, just to be clear, this was sitting on my chair when I got in this morning, so I've not taken, I don't know when it was filed, but I was off on Monday, so if it was filed in between Friday and Monday, because I was here Friday, then I didn't have sufficient time to review this. So if he wants to make a statement, he can make it now.
Garrett, do you have a copy of your letter? Are you able to read that?
Yeah, I can pull it up real quick. 1 second here. I'm sorry.
No problem.
It's loading. I'm sorry, Your Honor.
You're fine, take your time.
All right. In my letter, I said, since the incident, I've learned many valuable lessons. I'm sorry for being a burden in the court. I'd like to grow from the experience and still be able to have a good career and still be a valuable member to society. I'm sorry to keen assistance. Well, none of this ever happened. Just want to move on with my life, not this deal on my record as it'll greatly affect me in my future. Much more. I've never had so much as a speeding ticket, so this is not a normal occurrence. I'm currently working at full time helping coach members in the community at a local gym. I surround myself with people who like this are happening again. Future plans to apply to VA and see if I can help veterans. Having this somehow would deeply affect my chances in that job. I would greatly appreciate if you gave me the chance to redeem myself and after my sentencing, have my record cleared. I am always looking to better myself and be a part of that journey. Thank you for your time.
Thank you. Okay, the court has had an opportunity to review the report from probation, the pre-sentence report and the recommendation that your criminal history and driving record is in the file. And then just for the record, it does state here that you did get a speeding ticket in July of 2016. I don't know if you forgot about that one.
Oh, that was like almost like a reckless driving type thing. I was young and dumb, but sorry, Your Honor.
I'm not asking you to explain that. I'm just, you made a statement that you did not even gotten a speeding ticket, and that would be inaccurate. You have gotten a speeding ticket. Nonetheless, reckless driving would be worse than a speeding ticket, but you made the statement not me.
I'm sorry about that.
You don't need to apologize. I don't know if maybe you forgot. It's been some time. I do have your driving record here, so I didn't want you to leave here today and not know that that's on your driving record. Because if it wasn't you, I want you to get Mr. Basiga to help you out, okay? Figure that out as well. Okay, but it sounds like it was you. So nonetheless, the recommendation of probation is that you are a candidate that would be good for 769.4A status, so that will be granted. He did receive a copy of a receipt and a picture of the victim's broken glasses and request for restitution in that amount, as well as the victim impact statement. I will grant a request for restitution There will be a term of probation in the amount of 12 months probation. While on probation, sir, there's a $30 per month oversight fee that you're responsible for, okay?
Yes, Your Honor.
You're not to engage in any assaultive or threatening behavior while on probation. You're not to have any contact directly or indirectly with Ms. Kina Sisson, okay?
Yes, Your Honor.
You're not to purchase or possess a firearm or ammunition of any, or weapon of any kind while on probation. And you're also not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription, okay, sir?
Yes, Your Honor.
You will be required to submit to random preliminary breath tests and urinalysis testing while on probation. You would be responsible for the fees associated with that, okay?
Yes.
Do you have any questions so far?
No, Your Honor.
Okay, the recommendation of probation is for you, that they believe you would benefit from programming that will address conflict resolution and emotional management skills. So I'm going to order that you participate in any programming that they recommend to you, okay?
Yes, Your Honor, that's no problem.
Currently employed, I'm going to order that you maintain your employment while on probation, okay?
Yes, Your Honor.
You'll be required to provide proof of that to your probation officer. As to fines and costs, due to the fact that there was an entire jury here at the time that you decided to take the offer, I am going to impose a fine of $500, which is the maximum amount of fines that I can impose. This is a matter that pended for a very long time. This was pending before my court since 2020. Multiple jury trials was set, but specifically the date that you decided to plead, the jury was already here. I had to call the jury upstairs and explain to them that you were going to be entering a plea to the original charge, but someone's got to pay for that. The entire jury had to be paid. It cost us over $500 for that process, but you will be ordered to pay $500 in fines and costs. As to crime victim rights fee, by statute, I have to assess $75 there and the $50 state minimum cost. I'm going to order $307 in restitution, and 12 months of probation will amount to $360 with the $30 per month oversight fee. That's a total for $1,292. You'll be able to make monthly payments on that. So it's probably a little bit over $100 a month, okay?
Yes, Your Honor.
Do you have any questions about fines and costs?
No, ma'am.
Okay. Lastly, there's an advice of rights and probation early discharge here. It states here, you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you have completed half the original term ordered by the judge. You may request early discharge from probation after meeting the following conditions. A, that you have completed all required probation programming and you have not violated probation in the last 3 months prior to your request. If a hearing is scheduled, you have the right to retain or hire an attorney to represent you, but you do not have the right to court-appointed counsel if a hearing is scheduled to address your request. You may make your request for early discharge by completing a notice regarding eligibility for early discharge from probation, which is also known as the MC 512 form, and that form is located on the court's website. You, however, are on probation for domestic violence, so you would not be eligible to make such a request. Okay, sir?
Okay.
Okay. Do you have any questions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further from me. Thank you, Your Honor.
Thank you. And if I didn't say it on the record, I am granting 769.4A. So you're all set. Okay, sir?
Yes. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Have a good. Thank you.
Too.
Yeah. I wonder if that was a weaver like that. I don't know if they have that, but we could have been. Are we ready on Walsh?
I am, Your Honor.
I'm ready.
Is that Mr. Chapman? Okay. Wall, is that Nolly? Yes.
I got it. For everybody else, but not my. No, I get it. Isn't necessarily your best interest. Yes. If I know. She spread the word. I know, it's, I think that's bad practice. Clients get arrested and then they go through all the bonding.
The record in the matter of the people of the state of Michigan versus Molly Walsh, file number 21-02645. Councilor Pence, please.
Morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Molly Walsh, who is present via Zoom.
Thank you. Today was the date that was set for sentencing. I do have a pre-sentence report dated April 26, 2022. Did you get a copy of that report, counsel?
I received a copy of that this morning, Your Honor. Thank you.
Yes, Your Honor. I received it and reviewed it with my client. No additions or corrections to the report.
Proceed with any allocution.
Did you want the people to go first, Your Honor?
Yes.
So today we are here for Ms. Walsh, of course. The probation recommendations, I believe, are appropriate in this matter and would be asking that Your Honor adopt them. I do want to give just a little bit of information to help the court understand why it is we are asking that these recommendations be followed. In this matter, we had a very young child with very clear signs of abuse on his face. I understand it's Ms. Walsh's position that those injuries came from a single strike. However, there were markings on both sides of this child's face and both of this child's ears. The ears are highly indicative for multiple abuse instances, as noted by Dr. Gerton. And so I am hesitant to believe that this was the result of one strike. The reason that that's important is because it shows that it's not an accident. It's not a one-time lash out or loss of control. I think that Ms. Walsh is on a good trajectory at this point. I know that she has been working on her sobriety, has been working on individual counseling, and some other different things that I think will be beneficial for her and her two children. I actually first encountered Ms. Walsh as a victim on a case in this office against a man that I believe is the father to at least one of the children. I'm not certain about both of them. And he is actually in jail right now serving a sentence for abusing Ms. Walsh. So I know that her circumstances have not been easy. And at this point that she's single parenting these two young children, and I give her a lot of credit for that. But it's my hope that through this probation term with the 7694A status, that she will be able to work through any of those remaining barriers that she has, come out with a clean record, and come out just the best mom that she can be for these two boys. And I think that that's everyone's goal in this, Your Honor. So I believe the recommendations are appropriate and ask that you grant them or order them. Thank you.
Thank you. Mr. Keithley?
Thank you, Your Honor. Well, we would similarly be asking the court adopt the recommendation as the sentence in this matter. In a somewhat more positive light, obviously, Ms. Walsh, as indicated by APA Smith, has been involved with CPS. My understanding is she has been fully compliant. She is doing very well in her involvement there. As APA Smith noted, she has been involved in counseling. She has been doing her programming. Again, things appear to be going well on that front. With that in mind, rather than ordering any specific programming while on probation, we would just be asking that the court order that she stay in compliance with whatever it is that CPS is wanting Ms. Walsh to do. Oh dear, we've lost Ms. Walsh.
Okay, maybe she'll log back in. Off the record. Do we know where Mr. Chapman is? Oh, he's gonna get on my iPad, maybe? No.
I'm not sure. He's wearing the great yellow hoodie, I think. Yeah.
Your Honor, Ms. Walsh just emailed me, I believe, on her phone indicating her computer died. She is going to be logging back in as quickly as possible.
No problem. Okay, did you want someone to bring Mr. Ball up, or did you just want me to sign this and you can go talk to him?
I can just go talk.
Sounds good. We'll get your copy.
He's getting him.
So I can give them to him.
Oh.
Yeah.
That one may be too late.
Copy that. Thank you. Sorry.
No, you're fine.
More clear. Thank you so
Yeah.
much. Yeah.
Good one, thank you.
Thank you.
Okay, Ms. Walsh, can you hear us?
Yes, I am so sorry. My computer turned off. It notified me 15%, but then as soon as it notified me, it shut down. It didn't even wait any longer. I have it plugged in now. It should stay.
You're
It's
good,
working.
thank you. Okay, sounds good. Okay, and then Mr. Keithley, you were completing your allocution. I don't know if there was anything that you wanted to repeat or if you're ready for the court's ruling.
Just in summary, Your Honor, as I indicated, she's doing well in terms of her compliance with CPS. She's been going through programming there. Could be asking that rather than ordering specific programming, that the court essentially order that she stay in compliance with CPS as a term of probation here. Additionally, Your Honor, as APA Smith noted, she is currently raising 2 children as a single mother. The report notes that she's working at Peckham and her income while she is working is not extraordinary. We would be asking the court waive any discretionary fines and costs in this matter. Thank you, Your Honor.
Thank you. It's up for sentencing and the court has had an opportunity to review Ms. Walsh's prior criminal history in the pre-sentence report. And to be clear, there was no prior criminal history. It's a unfortunate incident, but as stated by both the prosecutor and by defense counsel, it appears that steps and measures have been taken and that Ms. Walsh, you seem to be on the right track. And I'm thankful that Ms. Smith provided some further insight. I mean, if you are in your own processes of healing from some abuse, it may have been challenging for you to know how to address, certain circumstances as parenting, young children. And so I think that you're doing what you need to do at this point. You're already in some therapy. I'm not sure if you're doing parenting classes as part of a CPS order. If not, I'm going to order that you do some. I think the recommendation from probation is appropriate. I will adopt that recommendation. I'll sentence you to 9 months probation and I will grant 769.4A status. While on probation, ma'am, you're not to engage in any assaultive or threatening behavior, okay? Ms. Walsh? Okay.
Yes,
You're
Your Honor.
not to, thank you. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or any other controlled substance unless you have a valid prescription, okay?
Yes, Your Honor.
The request is for you to undergo a substance abuse assessment based on information that you reported during your interview. So I am going to order that you have an assessment done so that if there's an issue there, it can be properly addressed during this time, okay?
Yes, Your Honor.
While on probation, you have to submit to random preliminary breath tests and your analysis testing, and you're responsible for the cost of that, okay?
Yes, Your Honor. Can I ask, is that potentially same day? Like they would call me in the morning and say, show up today to do this?
That is potentially the same day. You'll get information where you'll call in and see if your name or number has been called, and then you would have to go in and report for your testing. And I know they probably have some time constraints, being that you are a single mom and you work. You can discuss those issues with your probation officer.
Okay, I just want it known that I don't have my own transportation and I'm disabled, so I use Spectran, and they need to have a day's notice to take me anywhere. I could not afford the cost of a Lyft or Uber weekly, or I mean, if it was once a month, I might be able to, but depending on how often, I can discuss that.
I don't foresee you being tested weekly at all. This is not an alcohol related offense. And so we'll discuss, and I'll note that here in your file that you are reliant on Spectrum for transportation. And so your probation officer will be able to work with you surrounding that concern, okay?
Thank you very much, Your Honor.
Okay, and so. Do you have any other questions about the probation conditions I've outlined so far?
No.
Okay, I'm gonna order that you maintain your employment while you're on probation. Again, continue your therapy, and you must remain compliant with your CPS order while on this term of probation. Excuse me. There's a $30 per month oversight fee for probation, and you would be responsible for that, okay?
Okay. I just wanted to add to my situation that I did call the Child Behavioral Health Department through DHHS that weekend when my son came home and was demonstrating really concerning behavior and hurting himself and swearing. I don't like, we used timeouts. It was a really unprofessional babysitter. And my goal with my children is to instill self-love and gracious acceptance of others. I do not want to medicate or send him to therapy. I am still learning in the parenting. And when he came to me saying stuff like asking for inappropriate behavior to be introduced and around him, I did not know how to appropriately respond to that. So I do appreciate being able to work with the court. And while some people may not want to work with the government because of challenges, the goal, right, our responsibility as citizens to challenge the law and make sure it is to the best regulation and reliability. I'm very grateful for the time spent helping me learn to be a professional single parent for the time now.
Thank you.
It's been a great support and I really appreciate it, Judge Simmons.
Thank you. And again, those of us that are here on this matter, our goal is for you to win and for you to be the best parent that you can be for your children. That makes us all winners. Okay.
Yes, yes. Thank you very much.
So thank you for that. Thank you for that statement. So again, there is the $30 oversight fee per month for probation, and I recognize you're someone of limited resource, that you'll have the opportunity to make monthly payment on the fines and costs, which will include that. I want you to prioritize using your financial resources though for testing if that's required or any other programming that you may have to pay for. That's what I want you to prioritize. If we come down to the wire and that oversight fee is still pending, we can address that in the court, okay?
Okay, thank you.
Your Honor, if I may just include just briefly, in my experience working with the child welfare system and on the neglect abuse cases, oftentimes CPS or DHHS can pay for testing, can pay for the evaluations and things like that. If the person just lets them know that the court is ordering part of that as probation, they can order it as part of her CPS plan as well. And then that way the agency can pay for it.
Okay, that's good news for you, Miss. Okay.
Wonderful. Okay.
Okay, so as to fines and costs, their probation will be the $270. There's a $75 crime victim rights fee that must be assessed and a $50 state minimum cost that must be assessed as well. I will waive any discretionary fines and costs. For a total of $395. Again, the probation department will call you or contact you to go over this order, and they'll explain to you that you'll be able to make monthly payments on that, okay? Do you have any questions for the court today, Ms. Walsh?
No, I believe I know how to contact my probation office. But do you have a phone number so I could have the information together?
I can give you the number for probation. I don't know who your probation officer will be at this time, but the number for probation is area code 517-483-4424.
Okay. Would it be the same person assigned to do the evaluation? Risk
That's not
evaluation,
likely.
something? Okay.
It's possible, but it's unlikely. Okay, so, but we'll see. I think they're going through a little bit of transition down there, so it is possible. I think it was Miss Otten who did yours. Okay. Unless there's any other questions or matters, we're all set on that. And then there's an advice of right as to probation. It states you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risk and needs. Except for domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you have completed half the original term ordered by the judge. You may request an early discharge from probation after meeting the following conditions. A, that you complete all the required probation programming, and B, you have not violated probation in the last 3 months prior to your request. If a hearing is scheduled, you have the right to hire or retain an attorney to represent you, but you do not have the right to court-appointed counsel if you needed a hearing for your request for early discharge. Lastly, you may make your request for early discharge by completing the notice regarding eligibility for early discharge from probation, which is the MC 512 form. And that form is available on the court's website. However, ma'am, you are on probation for domestic violence, and so you would not be eligible to make a request on that form, okay?
Okay.
Do you have any questions?
No.
Any additional matters for the record?
Oh, Your Honor, thank you.
No.
No, Your Honor, thank you.
Good luck, Ms. Walsh.
Thank you all.
Thank you. Have a good one. Okay, I see Mr. Nichols here.
Your Honor, I have Deontay Chapman in a break room down here with your iPad.
Yeah, I see that it's on there, and that's what Mr. Nichols is here for, I believe. Mr. Nichols? Okay.
Yes, Your Honor.
For Chapman, correct?
No, I'm here for Mr. Bomar Griffin.
Okay, sorry. Mr. Keithley, you're here for Mr. Chapman.
I am.
You need to speak to him privately.
If I can ask Ms. Lacy, did any witnesses appear?
Yeah, she's here.
Oh, okay. Well, then I will speak with him.
Okay. Does he know how to go if I put him in a private meeting room? If I put him in a private meeting room on Zoom, does he know how to?
I don't know.
Okay, yeah, no, he needs to know how to. Oh, he did. He's in there. He's in your room, Mr. Keithley. Do I have that file?
He is in the private comment room now.
Bomar, do I have that file?
Some files to probation.
Sounds good, thank you. Mr. Bomar Griffin, are you there? Okay. Can you unmute, please, sir? Okay, we're on the record in the matter of the people of the state of Michigan versus Brian Bomar Griffin, file number 22-01002 FY. Council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Bomar Griffin, who is present over Zoom.
Thank you. Mr. Bomar Griffin, today is the date that I've scheduled to address a bench warrant failure to appear. Which, did I actually sign a bench warrant? I don't think I did. However, you were scheduled to be here on May 6th for a preliminary examination and you did not appear. So supposed to be here at 8:30 in the morning. What happened, sir?
I'm sorry. Unfortunately, my car got ran into, and I didn't know that it was a Zoom meeting. I thought I had to make it down to the court. And by the time I got in touch with my attorney to let him know, it was already too late.
Well, I had it that you were supposed to be here for an exam. Why would it be via Zoom?
I
believe he was.
Okay, he was planning to waive, Mr. Nickel? Is that what it was?
Yes,
Yeah.
it was planned to be a waiver.
Okay, sounds good. Okay. I think I requested to hold this for 48 hours. And then I think we did receive some communication from your attorney. So I don't believe I actually signed the bench warrant. So in the future, if you have a situation, especially at the circuit court where you're not able to make it, you need to make sure you get in contact with the court and your attorney. Okay?
Okay.
During that time frame in which you're supposed to be there, because a warrant could issue for your arrest, and while you're trying to take care of car issues or whatever, you could be ending up picked up on the warrant and in jail.
Okay.
When it could just be resolved by communication. So are we still looking to waive the exam? Is that what's going on, Mr. Nickel?
Yes, it would still be our intention to waive the preliminary exam at this time.
Okay, thank you. Was there an offer on this matter?
Your Honor, no offer at the district court level, but negotiations can continue in circuit court.
Okay.
In addition, Your Honor, the people would agree to unconditionally waive their rights to preliminary examination in this matter. We were intending to do last week.
Okay, thank you. And so, Mr. Bomar Griffin, you understand that you have the statutory right to have a preliminary examination here in the district court?
Yes.
You understand that at the time of your examination, you have the right to have the prosecution establish their burden of probable cause. So they have to establish that there's probable cause that a crime was committed and probable cause sufficient to charge you, the defendant, with the crime. You understand that?
Yes.
You wish to unconditionally waive that examination?
Yes.
Okay, so unconditionally means you waive it and you can't come back later and change your mind and say that you want to have that examination. So this matter will be bound over to the circuit court for further prosecution without holding any hearing here in the district court to establish sufficient probable cause. You understand that?
Yes.
Is anybody making any threats to you to get you to waive your exam?
No.
Has anybody made any promises to you to get you to waive your examination?
No.
Are you waiving it freely and voluntarily, sir?
Yes.
Find the matter over to the circuit court. Bind over date's going to be May 25th, 2022. You do not need to appear in court on that date. That's the date they get the file from this court. Okay, sir?
Okay.
They'll set your next court date. It's going to be a pre-trial in circuit court. Mr. Nickel will be made aware of that date. He'll be in contact with you. Okay?
Okay. Thank you, Your Honor.
No problem. Bond in this matter at 2,500 will continue. Any additional matters for the record?
Nothing for the people.
From the defense, Your Honor.
Thank you. You're all set, Mr. Bomar Griffin.
Okay, thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Don't I have this Beatrice Simona Martinez on benchmark already? No, should have been on another file. I only see this one case. Okay. Yeah, probation phase one, yeah, it's after this. Gallagher's just for review. Review community service. Okay, Rebecca Gallagher is here for a review. Mr. Keithley, is that your client?
No, Your Honor, that's Ms. Donnelly's client.
Okay, Ms. Gallagher,
Yes,
we're gonna reset your matter because it looks like you are scheduled for a forensic review or a forensic evaluation, that is, on the 17th. Did you get your notice?
I cannot drive down there. I physically can't drive down there and no one is answering my questions. So yes, I did get that notice.
Okay, your attorney can request for that to be held through video conference.
She will not return phone calls.
Okay.
And I have requested someone else.
You mean you
I have
requested another attorney?
I have multiple medical conditions and this is out of control right now.
When you say you're requesting someone else, do you mean you're requesting another attorney? Is that what you're saying?
Yes, another judge, another attorney, everything.
Okay, sounds good. Okay. Mr. Keithley is here from the Public Defender's Office. I can request that he have your attorney contact you. Oh, there she is. She's here. And I hate to disappoint you, ma'am, but you're not getting another judge, okay?
I'm entitled to be treated like a human, and I have not been. I don't even understand this when a conversation is being taken out of context to ask someone a question that is supposed to be helping you, and yet they give you the incorrect information, and now I'm sitting here talking to people who don't even care about the whole situation.
Okay, I'm not sure what you're talking about, but your attorney is here, so I'm gonna put you in a private meeting room with her. Ms. Donnelly, she has a forensic evaluation on Tuesday, May 17th at 9 a.m. She's saying that she's not able to drive there. I do know she doesn't live in this area, but this is scheduled to be in Saline, Michigan. I know that there's an option for you to make a request to have that evaluation via video conference. I'll allow you to discuss this with your client in privacy, okay?
Thank you, Your Honor.
No problem. And after that, she's free to go because it's just a review.
Liar.
Okay. Okay, are we ready, Mr. Chapman? Man. Whew. You think I did something to that lady?
Welcome back.
Justice for me. Mr. Chapman, you can come up here. Yeah, because we have to have a mic to pick you up. Okay, on the record in the matter of the people of the state of Michigan versus Deontay Chapman, file number 22-00781 SM. Council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Deontay Chapman, who is present in the courtroom.
Thank you. And today was a date set for a final pretrial. My understanding is that the necessary witnesses were present.
That's correct.
Okay, Mr. Chapman is present here in the courtroom. Are we continuing to trial on this?
Your Honor, my understanding is Mr. Chapman is going to be entering a plea this morning.
Okay. Was there an offer?
There was, Your Honor. The offer is for him to plead as charged, but the people would have no objection to him being sentenced under 7694A. We'd ask that he comply with all terms and conditions of the PBO and the no contact order to stay in place throughout the duration of any imposed sentence.
Okay, that's the understanding of the plea agreement, Mr. Keithley.
It is, Your Honor.
And Mr. Chapman, that's your understanding of what you're going to do today, sir? Okay, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, thank you. You can put your hand down. Mr. Chapman, you have the right to proceed to a jury trial on this matter, or you can waive jury trial and have a non-jury trial, but you have the right to have trial. And at the time of trial, you have several rights. One of them is the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecution bring sufficient evidence to prove each element of the charge against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to question or cross-examine any witnesses the prosecution intends to call, and you have the right to call your own witnesses or present evidence that you believe would further a defense to the charge. In order to plead guilty, you have to give up each of those rights, sir. Do you understand that? Okay, you want to give up each of those rights today? Is anybody forcing you to give up those rights today and plead guilty? Okay, I need you to speak up so my court reporter can pick it up.
I'm sorry. No, ma'am.
Thank you. Is anybody promising you anything to get you to waive your right to plead guilty?
No, ma'am.
Okay. You're currently on probation or parole.
No, ma'am.
And you understand that a guilty plea can result in a conviction that you may need to report to your current job? Okay, you still want to plead guilty at this time? Okay, you may need to put a conviction on future job applications. Do you understand that? I can't hear you. Thank you. And then lastly, if you are seeking any status under immigration, a guilty plea could impact any status request there. Do you understand that?
Yes, ma'am.
Okay. As to the charge of domestic violence, how do you plead, sir? Have a factual basis.
Thank you, Your Honor. Mr. Chapman, on or about March 19th of 2022, were you at an address commonly known as 1419 Rio Road in the city of Lansing, Ingham County, state of Michigan?
Yes.
And at that time, were you present with an Aubriana Richardson?
Yes.
And is that an individual with whom you had a dating relationship or have a child in common?
Yes.
And while you were there on that date at that location with Miss Richardson, did the two of you get into an argument?
Yes.
And it's that argument termed physical, right?
Yes.
And you ended up pushing Miss Richardson, right?
Yes.
Now, did she give you permission to push her?
No.
And you didn't have a legal justification otherwise, did you?
No.
I have no further questions, Your Honor.
Thank you, Ms. Lacy. Any questions?
No, Your Honor, the people are satisfied.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing will be June 28th at 8:30. Prior to sentencing, you need to meet with probation. You need to go down to probation before you leave here today. They're on the 5th floor. They will set you up for a pre-sentence report and investigation, okay? So they're gonna prepare a report for the court. They'll let me know whether or not you're eligible for a 769.48 status, okay?
Yes, ma'am. On this date, I'm gonna be late.
You can appear via Zoom,
Be on. Okay, thank you.
and we'll get you a Zoom sheet. Is there a blue sheet over there? Okay. You can appear via Zoom for your sentencing. Do you have any questions?
Mess up my job.
You said what?
This can mess up my job.
Well, I asked you, did you understand that you may need to report this to your job? I can't tell you, Bill, mess up your job. I'm not your job.
Okay.
But that was your opportunity to say, you know what, maybe I need to talk to my attorney. And maybe I need to talk to my, and figure out what my options are, because if this is gonna mess up my job, maybe I don't want to go this route. But you said you understood, so maybe you didn't understand. Is that what you're saying now?
No, I'm good.
Okay. Yeah, you may need to report it, but I can't tell you if you have to report this. I don't know anything about your job, okay, sir?
Yes, ma'am. Y'all have a good day.
Same to you. You go down to the 5th floor, okay?
Yes, ma'am.
Okay, let's see, Ms. Donnelly. Were you able to assist to the best of your ability, Ms. Gallagher's issue today?
To the best of my abilities, yes, Your Honor.
Okay, thank you.
Yeah.
For another review, yeah, we're gonna set it for another review. Yes. 30 days. June 21st at 9:30. It'll be June 21st at 9:30. Okay, let's see. Who's representing Beatrice Demoya Martinez or Demona Martinez?
It's, I believe it is Demoya Martinez, Your Honor. And I'm supposed to be.
I thought that I had her in warrant status on another matter, but I'm not sure. And then Hatcher, not here, I don't think. I think I'll be right along. Yeah. Rest of her things are closed. This time it's not showing up because they spoke to me. You go into the disposition. Oh, she was already done. Okay, sounds good. She was a, what is that? Is it set for something? Oh, okay. Just because we might, if she comes today, we might be able to take care of them. I think she pled on that file. Looks like sentencing. Okay. June 3rd. Sounds good. Okay. McCool is in custody? Yes. Okay, we'll have Sean get in.
So what does it mean when it says that you cannot, evaluations cannot be done? Does that mean like someone, a public figure has to really be referred to do it?
I have not. Or they have to actually know the address or whatever. We have to be able to confirm that.
Like just a Gmail, has to be, it has to be like something like mine.
No, I think it's just like,
Okay.
it can't be something that like they can't track.
Okay.
We gotta
Rebecca
be able-
Gallagher. She's the eviction. She's like, I need you, I can't go in there. I can't. I'm like, I need to be this by Zoom, but you have, you can't be cheaper.
No, she's got.
Yeah, you have no. No.
You gotta come here or. It's letter bullets. Probably, okay. Was it usually right now with someone?
Yeah, but it's a private email, that can be like.
Yeah, she's gotta either come and use like. I bet she's gotta use one.
Yeah.
Wow.
Well, she ain't coming down here anyway.
Let's stop here and up here.
She's not coming.
Okay, good morning, Mr. Miller. You're muted, sir.
On mute. Can you hear me now?
I can, thank you. Do you have an attorney?
No, I do not, but I can't see you visually.
Okay, did you start your video? Because I can see you, so I'm not sure.
Okay, I can see the courtroom now. Okay.
Okay, very good.
No, I do not have attorney on.
Okay, very good, thank you. Okay, we're on the record in the matter of the people of the state of Michigan versus Marcus Miller. I have 3 files. One is J040647, J073481, and J044894SM. Council appearance, please.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Thank you. And then Mr. Miller is proceeding without counsel, correct, sir? Mr. Miller,
Yes.
please state your name for the record, please.
Marcus Terrell Miller.
Thank you. Today is the date that's set for, or was reset for a motion to set aside conviction on each file. We adjourned this matter because we were waiting to see if the Attorney General was going to file an opinion. They've not filed one, at least I don't have one in my file at this time, so I'm going to proceed with the hearing. Is the prosecutor going to make an opinion on this?
No, Your Honor, leave it to the court's discretion. File number
J044894 is for a misdemeanor assault or assault and battery. File number J040647 is for a misdemeanor check non-sufficient funds, $100 or more, but less than $500. And J073481 is for misdemeanor malicious destruction of a building less than $200. And Mr. Miller, you're requesting to have those matters set aside because it's been at least 5 years since the sentence was imposed or discharged from imprisonment, probation, or parole. Can you tell the court what you've been doing since that time?
Since that time, Your Honor, I was incarcerated from March 26, 2012 until March 15th, 2021 for conspiracy to sell drugs. But during my whole incarceration, my 10 years, I never received not one discipline report. And since my incarceration, I recently passed my state real estate test. I work at John Millen's company. I work between 50 and 60 hours a week, Monday through Sunday, from 2:30 afternoon to 12 o'clock at night. And I've been really staying out the way and trying not to make doing and not making the same mistakes that led me back to incarceration in the first place.
Well, congratulations to you on passing your real estate examination, but also for you to spend that amount of time in the Department of Corrections without any behavioral issues. That's a huge accomplishment in and of itself, just because of the nature of the environment that you're in. Again, I want to applaud you and congratulate you on both of those accomplishments. And hopefully, looking forward, this is a new chapter in your life. I know you have not been out for a long period of time, but it sounds like you're doing what you need to do and putting yourself in position to be a productive member of society and someone who won't return back to that environment that you were just released from. So with that being the case, then I think that you would, or your requests are consistent with circumstances and behavior to set aside the conviction, and that it will be consistent with the public welfare. So I'll grant your request to set aside your convictions in each of these files. And those will be signed and dated for today, okay, sir?
Yeah, yes, Your Honor. Thank you.
Yes.
Hope it helps, but I did just find a letter from the Attorney General that my office received on April 1st, wherein the Attorney General's office was not taking a position either.
Thank you. Mr. Miller, did you have any questions today, sir?
My only question I would have for the court is, how long will it actually take to set the conviction aside? Do it have to go to the Michigan State Police Department, 30 days, 45 days before I can, it actually shows up?
How long? I can't speak to how long it'll take over at the Michigan State Police. I couldn't give you any estimate about their timing. Do you have any information on that at all?
We mail it out today, and it usually takes them 2 to 3 weeks to make it disappear and become another.
Okay, my understanding is they'll get mailed today, and it has been taking about 2 to 3 weeks for them to make it disappear from your public record, okay?
Okay, thank you, Your Honor.
Sorry?
The court record itself will be made non-public today.
Okay, the court record will be made non-public as of today, but your public record, the state police will make those changes within hopefully the next 2 to 3 weeks, okay?
Okay, thank you, Your Honor.
You're welcome. Any additional matters, sir?
No, Your Honor.
All right, good luck.
Thank you.
You're welcome. Someone join from an iPhone?
Yes, ma'am.
What's your name?
Darryl Johnson.
Okay, Mr. Johnson. Finally, is that your matter?
Yes, Your Honor.
Okay. You ready to proceed on that?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Darryl Quinn Johnson, file number 21-02722 ST. Council appearance, please.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Darryl Johnson, the second who is appearing by Zoom.
Thank you. Today's date that was set for a pre-trial. I think this matter was reset a few times. The last time we were here, there was some outstanding. Not sure where that's coming from.
I'm sorry, phone call.
Oh, okay, thank you. There was some outstanding video evidence. How are we proceeding on this at this time?
Your Honor, it's my understanding that, and I do have a copy of the appearance that was filed by Ms. Donnelly back in April. Unfortunately, for some reason, it's still not showing up in my system, so she has not received the video evidence yet. I do, however, have it in my possession, so I'm going to forward that to our discovery unit again and ask them to send the evidence to her. I don't know what, it did take an extremely long period of time to get the video.
Yeah, because
from
you know,
the police department.
Okay.
I don't think this is a case that we don't typically ask for video on ticket cases. I think that caused some issues.
Okay, so you have the video. You're going to turn it over to Ms. Donnelly today.
Yeah.
And then what's the next step on this? Because we've been coming back and forth on this for a lot of time now.
Your Honor, I don't know if I formally
Was there
made
an offer on that?
the offer or not, but the people would be willing to offer for Mr. Johnson to plead to a civil infraction of impeding traffic if he was willing to do so.
Okay. Sounds good. So what we'll do is we will adjourn this matter so that Ms. Donnelly can have an opportunity to review the video and to discuss the offer with her client. May 17th at 10:30. Set it for May 17th at what time? At 10:30. Any additional matters for the record on this?
Nothing.
No, Your Honor.
Thank you. Okay, Mr. Johnson, we'll see you May 17th on this.
What time?
It's gonna be at 10:30.
Thank you.
You're welcome. I see Brandon Evans. Who's handling that matter?
Yes.
I am, Your Honor.
Do you need to speak to him?
No, Your Honor. I believe we're prepared to proceed.
On the record in the matter of the people of the state of Michigan versus Brandon Evans, file number 22-01008. I'm sorry?
I couldn't hear.
Mr. Evans, can you please start your video?
Yes, Your Honor.
Okay, thank you. Again, file number 22-01008. Council appearance, please.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Brandon Evans, who's present via Zoom.
Today's the date that was set for a pre-trial. How are we proceeding on this matter?
Thank you, Your Honor. At this time, we would be asking that this matter be set for a final pretrial and jury trial.
Was there an offer on this?
Your Honor, there is not necessarily an offer, but we would ask that if he were to plead guilty, he would also be screened for the domestic violence court, and we would deliberate no upfront jail.
Domestic violence court, Judge Ward's domestic violence court?
Yes.
Well, that's not an offer because I think he has to have a DV second and he would need to be screened before he could plead guilty.
That's fair, Your Honor. I'm still unclear on the DV court requirements. I don't typically make those offers. All I know is he does have a prior DV case that was dismissed. So
Okay, sounds
I don't
good.
know if that would qualify him or not.
Okay, sounds good. So what I'll do is I'll set up a final pre-trial and jury trial. Final pre-trial, May 17th.
Oh, you say May 17th?
Yeah.
I'm gonna need at least another week so I can submit it.
Okay.
Sorry.
So May 24th. And so he is going to be screened for domestic violence court. Is that correct or no?
I'm gonna send over an email and see if I can get that clarified, but I would like him to be screened if he's at all eligible.
Okay. And then the trial June 28th. Okay, so final pre-trial will be May 24th at 8 a.m. in person at the court. Jury trial will be June 28th at 8 a.m. in person at the court. You have any questions today, Mr. Evans?
No, you said June?
That's correct. For your trial.
June. All right, it's June 8th.
No, your final pretrial will be May 24th in person here at the court, and then your jury trial will be June 28th.
Okay. So it's June 28th and May. Hold on, I gotta write it down. You say May
Good
24th,
idea.
May 24th, and June 28th
Correct.
in court.
Okay, did you write that down, sir?
Yes.
Okay, and so are you still at the address on Hughes?
Yes.
We will also mail you a copy of those dates, okay?
All right.
Do you have any questions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people.
Just a point of clarification, Your Honor. I don't believe that this is a case where he would even be eligible for the DV court. My understanding is that has to be either a domestic violence second offense or a domestic violence or an aggravated domestic violence.
That's my understanding as well, but Ms. Lacy did indicate that she believes he does have another domestic violence, and she doesn't know if that'll make him eligible. I'll allow the domestic violence coordinator to respond on that.
All right. Nothing further for the record, Your Honor.
Thank you. Okay, you're all set, Mr. Evans.
All right.
Thank you. Anybody know where Miss Beatrice Demoya Martinez is?
Your Honor, I did speak with her last week, but I have not been able to get a hold of her this morning.
I'm here.
Oh.
Can you hear me?
I can hear you. Thank you. Can you start your video, please?
Yes. Okay.
Did you need to speak to her, Ms. Donnelly?
Like I said, we have spoken previously, so I believe we're ready.
Very good. We're on the record in the matter of the people of the state of Michigan versus Beatrice Demoya Martinez. File number is 21-02009. Council appearance, please.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
An Assistant Public Defender, Sarah Donnelly, on behalf of the defendant, Beatrice Demoya Martinez, who is appearing separately by Zoom.
Today's the date set for a pre-trial. How are we proceeding on this?
Your Honor, Ms. Donnelly has made me aware that the dog has been rehomed. For some reason, I cannot find Ms. Demoya Martinez in my system.
Maybe if you look under Demoya Martinez, because they have her name spelled incorrect.
There we go. Well, I don't actually show any tickets or anything in the system for her either. At this time, Your Honor, I'm gonna go ahead and dismiss it, so we're not coming back until I get it. It makes no sense to keep everyone here if the dog's been rehomed and I don't even have it. So
The people are moving to dismiss, so you're all set, okay, Ms. Demoya Martinez?
Yes, ma'am. Thank you, Your Honor. You have a good day.
Thank you.
Bye now.
Okay. So the jail, for some reason, does not put Mr. McWolf on, even though he was on the jail list.
He was transferred.
Okay, sounds like he was transferred to Ionia, so we're gonna need to reset that.
You can do May 24th at 9:30.
Is that enough time for it?
I know.
He needs an MDLC rep if he's in Ionia.
We can do June 21st.
We're gonna reset it for June 21st at 9:30. Oh. I didn't see Mr. Hatcher join us today.
Your Honor, just for Mr. McCluth, he is in Ionia County Jail.
Correct, that's what we said.
Okay, I thought you heard like MDOC. I just want to make sure.
Oh, okay, thank you. Yeah, he was transferred to Ionia, so we're resetting it so that we can have sufficient time for a writ. Logan Naval, who's representing him? Is that yours, Mr. Keithley?
Yes, Your Honor.
Okay, have you heard from him? Because he's not here.
My apologies. I have not. I know he had a prior missed hearing where I believe he just didn't understand that he had a court date, and then he appeared and got arraigned on the warrant and was given today's date. I have not heard from him since that time.
Okay, sounds good. I'll issue a big warrant again. And let's see, 10 o'clock, who's supposed to be? Anyone know where Amber Valencia is?
Your Honor, I don't have good contact information for Ms. Valencia, so I haven't been able to get a hold of her.
Thank you. Is Hatcher already in visual sense? Looks like he's been in visual sense since 2020. Yeah. Okay, sounds good.
Did he not get arrested?
Doesn't look like it.
Okay.
Yeah, I think we just got a report, and so it should have been set for a P 53. Yeah. Content, I think so. Pursuant to temporary-
She doesn't have Wi-Fi, right?
Okay. Nothing's happening. It's not doing this.
You're in. It's just taking a minute to load everything up.
Good morning, Mr. Bailey.
Yes. Good morning.
Mr. Keithley, did you need to speak with your client?
Not at present.
Okay. Mr. Keithley, did you need to speak to Mr. Bailey?
No, Your Honor.
Mr. Bailey, are you there? Okay. Well, on the record in the matter, the people of the state of Michigan versus Douglas Bailey, file number 22-00832. Council appearance.
Morning, Your Honor, Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Douglas Bailey, who is present phase room.
Thank you. Today was the date that was set for pretrial. How are we proceeding on this matter?
Your
Well-
Honor, I believe the last conversation I had with Mr. Keithley, I was not in possession of any materials. It does look like we have received them. I don't know if he has received them.
Well, Your Honor, I did receive a report relating to Mr. Bailey. However, it's not a report relating to this alleged incident. So as the court may remember, Mr. Bailey had two files back in April. On April 19th, we were here on this file and the other file. The court dismissed the other file due to the fact that it had been pending so long and I had not received any discovery on that file. At this time, Your Honor, and then reset this matter. At this time, Your Honor, Mr. Bailey was arraigned on April 8th. It looks like my appearance was entered shortly thereafter, and I still have not actually received any discovery in this matter, and I'd be asking this matter be dismissed as well.
It's not been that long. It looks like it's been exactly a month from the time of the arraignment. I'm not sure what is going on with the tickets, but there's a copy in my file, so the original is in this file, so there's got to be a copy somewhere at the prosecutor's office. I'll reset this matter so that discovery can be exchanged. Did you say you didn't have a copy of it?
I didn't originally. I have one today. I'm gonna ask that they send this to Mr. Keithley. I don't know what report he has because the last file I have for Mr. Bailey is from 2015. And this report that I'm reading corresponds with the ticket, so I don't know.
Sorry, what's the date on the ticket that you have, Ms. Lacy?
1/24/22.
Your Honor, this incident date is allegedly March 18th.
Yeah, that's the ticket I have.
That's not what I have. So then it makes sense. I don't have a report as it regards to March 18th, so I don't know. Again, I don't have it, so I don't know if Your Honor is inclined to dismiss it. It's beyond my control. It comes from the Ingham County Animal Control. There's nothing else I can do. I don't have any updated. I don't have a separate case. This is showing up with the date of incident that I have 1/24/22 as this CTN that's assigned to this specific file. So I don't know where the confusion is either. But it is-
Was the other ticket the February, that date? Is that what the confusion is?
I don't know what the confusion is, Your Honor, but it appears that the prosecution is not actually ready to proceed in this matter. They're not really proceeding with due diligence here. I don't know where the disconnect is, and I'm not laying this at Ms. Lacy's feet. I understand this isn't her fault, but the law enforcement agency isn't giving the prosecutor the ability to proceed in this matter, and I think dismissal is warranted. Certainly, if they do get the information to them, they could refile in this matter, but it's been over a month. It's been almost 2 months since the ticket was supposedly written. And that was never furnished to the prosecutor and never furnished to me.
Sounds good. I'll grant your request to dismiss the case. Case is dismissed without prejudice. You're all set, Mr. Bailey. Mr. Bailey, you're muted, so if you're addressing the court, I can't hear you.
Thank you, Your Honor.
You're welcome. Thank you. Oh.
I'll wait for them to disconnect, right? It doesn't
You
say
hit the
that.
red button, it should say leave.
Okay, I will when it comes up.
Hello,
Yes. What's your name?
Rhianna, Merch.
Please start your video.
Okay, yes.
Is this your client, Ms. Donnelly?
Yes, Your Honor, and I'm ready to proceed.
We're on the record in the matters of the people of the state of Michigan versus Rhianna Murch, file numbers 22-00347, 00349, 00350, and 00351. Council appearance.
Morning, Your Honor, Andrea Lacy appearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Rhianna Murch, who is appearing separately by Zoom.
Thank you. Today's the date that was set, excuse me, for pretrials and one count of dog at large. However, that has Smirker's name on it. I'm not sure why. I just say the prosecutor's name in the file. Okay, one count of dog at large, and there's 3 counts of dog licensing, vaccination. How are we proceeding on these?
Your Honor, Ms. Donnelly did provide me with the Egan County dog license for dog Blair. The people at this point would be willing to dismiss the dog licensing case that relates to that incident, but I do not have any updates as to the dogs named Scraps, Kelly, or the dog at large.
Which one of these files is for Blair?
Your Honor, I did provide the last pretrial conference. I provided the proofs for Callie and Scraps. Blair was the only one that was missing. That's why I provided this time.
Let me make sure I have it. I that may be true, Sarah. I don't see it right now. Can you send them over to me again, Sarah? I can't find them in my email. I don't know if we dismissed that last time.
I'm just gonna forward you an email from Ms. Murch. It should include in the chain all of the proofs.
Perfect, thank you.
All right, I've confirmed that that's being sent over. In regards to the dog, the at large, the only thing we have on that is that Ms. Murch identified the problem with why it was Scraps, right? Ms. Murch?
Yes.
Why he was getting over the fence, you made it higher?
Yeah, I did make it higher. And also secured a chain into the ground with like some cement and a bucket. And whenever we're outside together, I just make sure he's on a chain. We go out there, go to the bathroom, and then we come back inside. Or every time we're inside together, he's supervised now.
Your Honor, I did receive the additional dog licenses from Ms. Sally. I apologize. I don't know why they were not in my email or why I could not find them in my email. Based on that and the defendant's description of the changes that she's made to the yard and it sounds like the routine of taking Scraps out, we would be willing to dismiss all charges at this time.
Okay, these matters will be dismissed. Do you have any questions today, ma'am?
No, thank you so much. I really appreciate it.
Thank you. Have a good one.
You too. Bye-bye.
Bye.
Thank you. Bye-bye.
Anybody heard from Keith Donnelly?
I have not, Your Honor.
I'll issue a picture on it.
All right.
I think that's all I have for the morning. Did I miss somebody? I don't think so. And you got a busy afternoon, so.
It certainly seems to be.
All right, you all enjoy your lunch.
See you this afternoon, Your Honor.